Hello and welcome to Timmy Matt Law with me, Mr. McClellan. We are going to concentrate on Section 18, wounding and grievous bodily harm under the Offences Against the Person Act 1861. And just to point out the blindingly obvious to you, this video is about Section 18 offences and not Section 20 offences. If you want to find out all about those, go and check out my video on Section 20 offences. I would recommend that you do that because it will mean that this material makes much more sense to you. When it comes to Section 18 offences, they're considered to be indictable offences. That means that they will be tried in the Crown Court and they carry a maximum sentence of life imprisonment. So therefore they are very serious. Indeed, they are the most serious non-fatal offence that we have studied, including assault, battery, assault occasioning actual bodily harm, Section 20 offences, and now we are up to our Section 18 offences. Now, when it comes to your scenario analysis, it is relatively straightforward to spot a wound or a grievous bodily harm. The slightly trickier bit is to actually label these offences correctly. So, in order to help you do that, take a look at this section here. This is there to enable you to get the right terminology when it comes to labelling your Section 18 or Section 20 wounding and grievous bodily harm. So if you think a wound falls under Section 20, you need to label it as a malicious wounding. The defendant can be charged with a malicious wounding, or alternatively, the defendant can be charged with inflicting GBH under Section 20 of the Offences Against the Person Act 1861. In contrast, if you think a wound or a GBH falls under Section 18, use this terminology. The defendant can be charged with wounding with intent or alternatively causing GBH with intent. You will note that there are subtle and also significant differences between these labels here, not least the words inflicting and then causing here with respect to GBH, and of course the inclusion of with intent when it comes to your Section 18 offences. Make sure you use that terminology when you are working with these offences, and it will just improve the quality of your answer. Indeed, many students don't use that terminology and their answers suffer just a little bit because of that. Now, when it comes to Section 18 offences specifically, here is the definition. A word of warning, it is quite long-winded, a bit of a mouthful, so do bear with me. So, Section 18 offences can be defined as whosoever shall unlawfully and maliciously wound or cause grievous bodily harm with intent to do some grievous bodily harm or with intent to resist or prevent the lawful apprehension or detainer of any person shall be guilty. Told you it was a bit of a mouthful. On the good side though, I wouldn't expect students to learn that definition word for word. More importantly, what students should do is actually remember the key elements of it and indeed understand how they can be applied in practice. And for that, we always use case law to guide us. And we're not going to do anything differently here. Now, as a starting point, we're going to focus on three key words which are pretty easy to grasp, simply because they retain the same meaning as they did under the definition for Section 20 offences. The key elements are unlawfully, wound and GBH. There they are, unlawfully, wound and GBH. So to start off with the word unlawfully, obviously the act which causes the wound or the grievous bodily harm must be considered to be unlawful, against the law. So there shouldn't be any reason for a successful defence with respect to the issue of self-defence or consent to muddy the waters, as it were. There's no legal justification for the act which causes the wound or grievous bodily harm, and therefore it can be considered to be unlawful. When it comes to a wound, well, we know that a wound is a break in the continuity of the skin leading to blood loss. The blood loss must be external blood loss. Internal bleeding does not count. And then finally, the GBH, grievous bodily harm, means serious harm or really serious harm. Don't forget to consider your characteristics of the victim with respect to their age or any vulnerabilities that they may have. Don't forget also that an accumulation of minor injuries can constitute GBH. Also, don't forget that a psychiatric injury, so long as it is diagnosable, can constitute GBH. And finally, do remember that the question of what serious harm is an objective question to be answered by the jury. Okay, so they decide effectively what serious harm is. So that's those three cleared up. Now let's go to a term that is different. It's not included in the definition for Section 20 offences. It's exclusive to this definition of Section 18 offences. And it's the word cause. Now, of course, when you get the word cause in a definition, normal rules of causation apply. But in this context, the word cause means that an act or omission must cause the wound or GBH. And that differs a little bit from your Section 20 definition, because in that definition they use the word inflict. So in the Section 18 definition it's cause, there it is, but in the Section 20 definition it's the word inflict. Now, when it comes to the word inflict in the Section 20 definition, that just means there has to be an act which causes the wound or the GBH. In the Section 18 definition, the word cause means an act or omission can cause the wound or the GBH. So therefore you can be liable based on an act, that's fairly obvious, but also an omission under the Section 18 definition, not under the Section 20 definition. So remember what an omission is. A person can only be liable for an omission, a failure to act, when they have a duty to act. I would suggest that that would be quite rare, in the sense that an omission causing a GBH would be quite unusual. Wouldn't expect it necessarily to appear in a scenario, but there's no reason in theory why it wouldn't. So therefore, obviously we need to prepare accordingly. So just remember that the word cause means an act or omission which causes the wound or GBH. Now moving on, let's get to the nub of the matter, the heart of the issue, this question of intent and what that actually means. And of course, there you've got with your labels of Section 18 offences, what makes the difference between Section 20 offences and Section 18 offences largely boils down to the issue of intent. So here we go. When it comes to the issue of intent for Section 18 offences, the defendant needs the specific intent to cause GBH, or the specific intent whereby the defendant could foresee serious injury as being virtually certain. So this form of intent, specific intent, was outlined in the case of Belfin, 1976, and that was where a defendant slashed the victim with a razor blade across the chest and the face, causing serious harm. Now, the judge ruled in that case that in order for the defendant to be convicted of a Section 18 offence, they had to have the specific intent to commit the grievous bodily harm or indeed the wound. And it was ruled that the defendant didn't have the specific intent for those consequences, and therefore it was more appropriate that they were convicted for a Section 20 offence. The bit that's important for us is that the judge did clarify that in order to be found liable for a Section 18 offence, the defendant needs specific intent. Well, what does that mean more specifically? Specific intent can come in two forms. Specific intent to cause GBH. So in other words, the defendant must intend the particular consequence of serious harm. Whether that comes in the form of a wound exclusively or GBH, which obviously means serious harm anyway, it doesn't matter. But the defendant must have the specific intent to cause serious harm. And that can be respected as direct intent. So that obviously emanates from the case of Moen, 1976. You'll be familiar with this case when you studied the mens rea. And in the case of Moen, the defendant was driving towards a police officer who was directing the defendant to slow down. The defendant did slow down, but then sped up about 10 yards away from the police officer, causing the police officer to take evasive action, diving out of the way, and there they suffered injury because of that. And that whole case rested on this principle of what direct intent is, and it is direct intent in the context of a Section 18 offence where the defendant intends to cause the particular consequence of GBH, which is why, in a nutshell, Section 18 offences are much more serious than Section 20 offences, because the defendant has intended to cause the serious harm with respect to Section 18 offences. Specific intent can also come in the form of this principle here. The defendant could foresee serious injury as being virtually certain as a result of their actions, as outlined in the case of Woollin, 1998, and Matthews and Elaine, 2003. And again, you should be familiar with these cases when you studied the mens rea. And indeed, this principle of the mens rea has been developed through a variety of cases. You may remember Nedrick as well, but I'm just going to fish out a couple of them just to illuminate the point. In the case of Woolen, the defendant grabbed a baby and threw the baby towards its pram, missing the pram and hitting the wall, and the baby suffered serious injury as a result. And on that basis of the defendant foreseeing serious injury with virtual certainty, they were found liable. Similar principle in the case of Matthews and Elaine, 2003. So this is where the defendant and their acquaintance were messing about near a river, and actually the defendants pushed the victim into the river knowing that the victim could not swim, and the victim ended up drowning. And of course, again, the principle whereby the defendant or defendants could foresee serious injury as being virtually certain as a result of their actions, well, there it is established as well. So that can come under the form of specific intent. If the defendant can foresee with virtual certainty that their act or indeed their omission will cause a GBH, serious harm, therefore you can find them liable of a Section 18 offence. Now, moving on to this rather curious part of the definition, which makes it all the more long-winded, is this statement here. I'll just read out the statement and then put it into plain English for you. Intent to resist or prevent the lawful apprehension or detainer of any person. This talks about the context of the defendant resisting or preventing lawful arrest. So I'll say that again. This is where the defendant resists or prevents lawful arrest either of themselves or of another person. Now, the curious element about this is that some of the criteria for Section 20 appears to apply here, and yet, if you like, it elevates the offence into a Section 18 offence. And let me give you an example of how this works. If you have a defendant who intends some harm against the victim, who happens to be a member of law enforcement agencies, the obvious example is the police. So I'll start again. If the defendant intends some harm against the police or is subjectively reckless as to whether some harm is caused, and their actions then lead to a GBH, serious harm against the police officer, they won't be charged with a Section 20 offence. Actually, they will be charged with a Section 18 offence, the more serious offence. And the logic behind that curiosity is that it offers the police greater protection. So I'll say that mini scenario just again. If you have a defendant who is intending to cause some harm or is subjectively reckless as to whether some harm is caused, that would ordinarily be the mens rea for a Section 20 offence. But because the defendant is resisting arrest or preventing arrest of themselves or another, and the arrest is lawful and the defendant is aware of the arrest taking place, if the consequences of their actions lead to really serious harm, GBH, they will be found liable for a Section 18 offence. Therefore, you are in a lot more trouble if you are subjectively reckless or intend some harm against the police and it leads to really serious harm being committed against them. The book will be thrown at you because you'll be found liable not for a Section 20 offence but for a Section 18 offence. That will be quite rare, of course, to appear in scenarios again, but once more, we prepare accordingly. The key bit to remember is that crucial difference between Section 18 and Section 20 offences. And if you remember this, bar nothing else, then you'll be doing really well and you'll be setting yourself up for a good performance in any answer that you deliver. So do remember that Section 20 offences requires the mens rea of intention or subjective recklessness to cause some harm. That's why the punishment given, the sentence given for a Section 20 offence is so much lower than it is for Section 18 offence, because the defendant just has the intention or subjective recklessness to cause some harm, but for Section 18 they have the intent to cause serious harm, and therefore the sentence is much stiffer in the context of a Section 18 offence. Hope that was all useful for you. Thank you very much.